I think a lot of us have found out the hard way that once someone passes away and the will, it's time to talk about that, it has to go to probate. What is that? It's like a mystery.
Today, we're bringing in Jeff Barnett and Keith Ludy of Barnett and Ludy Law Firm to talk about this because I think it is a really confusing and sort of unknown process. Thanks for being with us today.
Yeah, thank you for having us.
Let's start with what exactly does probate mean and what's the process?
Sure. The word probate essentially means to prove something. And what we're proving to a court, a probate court judge, is that a person's last will and testament is it's valid, no reason to question it. It complies with state law and it accurately reflects the true wishes of the decedent, the person who passed away.
Mm-hmm. I think there's some people out there who think that, well, if I have a will, I don't have to go to probate, but that's not the case, correct?
Sometimes there is that misconception out there that that if I have a will, I don't need to go to probate, or even sometimes if the house is in both names, I don't have to go to probate. It's just going to automatically be mine. No, that's not. So that's definitely not the case. That that just because you have a will, you don't have to go to probate. Sometimes it is. Sometimes it is, but it's not because you have a will. Sometimes there are situations that that lend themselves to that mean that you don't have to go to probate. When you have a will, if there are probate assets, if there are assets at the end of life that need a court process, a probate process to change the title of those assets into the names of the beneficiaries, then yes, you have to go to probate. And that's true whether you have a will or whether you don't have a will.
Good description with the assets.
Gotcha.
Yeah,
yes, assets. Yeah. And you mentioned when you don't have a will, that likely makes things a lot more complicated. So we're not going to even try to address that in this interview. We're going to stick with probate process when you have a will. How long would people expect for it to take?
Well, it depends upon where you are, what state, what county. We can certainly speak to the Central Texas area. In our part of the country, probate usually we tell our clients is about 3 or 4 months, start to finish. Sometimes the court dockets are a little more jammed up. We do hear stories from other states, California in particular. Apparently, it can take substantially longer to get through the probate court, but from start to finish, 3 or 4 months is pretty common from what we hear around Central Texas.
Mm-hmm. Which isn't too bad, but when you have assets, when you have bills, when you have so much things you have to get done and you want to do it now, is there any way to speed up the process?
Sure. To some degree, you just may staying in touch with your attorney, taking the earliest possible court date, things like that certainly can, obviously getting in to see the attorney with the will and with the death certificate as soon after death as possible, speeds up that process. But there are, when you file a will for probate, there's a mandatory 10-day posting period, and then you have to get on the court's docket. Yeah. And depending upon the type of docket that you're in, and depending upon the circumstances, that can take anywhere from a week or two up to a couple of months, to get on the docket, but depending upon the county or the jurisdiction that you're in. But it's it's still not a terribly long time like it is in some places, like some other states.
Mm-hmm. Do you have to have an attorney to go through the probate process?
So generally, you're supposed to have an attorney. And so the situation is that in any of the big counties in Texas, and everything right here in the immediate Central Texas area, Travis, Williamson, Bastrop, Bell, whatever, they are going to make you get an attorney. Some of the more rural counties, I have heard stories where somebody was allowed to not get an attorney by the local judge. That is something that a judge theoretically can do. But an estate is really a distinct entity from the person who died, and also the person who's trying to be appointed as the executor. Those are, the person who died is one person. The person who's trying to be appointed as the executor is one person, and the estate is a third entity. And so that is when you're, when you go to court, you can only represent yourself in court if you're not an attorney. If you're, but only if you're an attorney can you represent yourself. I'm sorry, represent somebody else or another entity, and that's the basis for that rule of needing to have an attorney.
So in some ways, the attorney is representing the estate or the will.
Yes.
Okay.
Yes, exactly.
Yeah,
Okay.
that makes sense. Those of us who are not in the legal profession hear about trusts, and we've done an interview about trust to try to understand it more. But you hear about trust and that you don't have to go through probate if you have a trust. Is that true? And if so, explain that to us.
The official answer would be maybe, because
It depends.
It depends upon what you've done with the trust. We've run into people who come into our office and say, "Hey, many years ago, I had an attorney set up a trust," and we ask them, "Well, what's in the trust?" And they look at us and like, "What are you talking about?" We say, "Well, a trust is like a legal bucket." And whatever you put into that legal bucket will never have to go through probate. That's why people set up trusts. So if you've put everything of substance into the trust, then no, there's a very good chance you won't need to go through probate. But if you didn't put everything in the trust, you might wind up having both.
Yeah.
Yeah.
But anything that's in that trust, you still don't have to worry about. Even though you're going through probate for other things, if it's in that trust, you don't worry about it at all, correct?
That's correct.
Gotcha. So what happens with, say there's outstanding bills, there's a house payment that still needs to be paid, there's funeral arrangements or expenses that need to be paid on behalf of the person who passed away while it's in the probate process? Does somebody have to sort of front the money and then get paid back later, or how does that work?
So officially, the creditors basically have to stay at bay, and whether that's a mortgage company or a credit card company or whatever, the estate is responsible for those expenses. And when somebody has died, somebody, whether it's the executor or another family member, should contact those creditors and say, hey, this person died. We need some time to get into probate. And those creditors, are required, by law to forbear, to kind of stay away for a little bit and give people time. But that can be a little bit of a messy process as well. And so what we tell people is that while you have no legal obligation to front anything for the estate, if the money's available, either on a credit card or somebody has enough money in the bank or whatever, and they'd like to go ahead, as the incoming executor or as a family member to go ahead and front some expenses, they certainly can be reimbursed right off the top before any other distributions are made, if they want to go ahead and front those expenses, but they are not required to.
And if I may add one thing, just to make sure it's clear to people. Having authority to act is very important.
Oh, yeah.
Many times somebody may be a power of attorney for their loved one. And the power of attorney, of course, expires when the person dies. You can't go into the bank after a person dies and use that power of attorney to move any financial arrangements that you need to do. And if you are named to be the executor in the will, essentially I compare it to having the executor is like a light bulb. That's in place and ready to go, but what you have to go in front of the judge and be approved, and the judge flips the switch on that light bulb, giving the executor power. So even if you're named in a will, you're not officially, you're like the first candidate to be the executor, but you don't have authority to act until the judge says so.
Yeah, you can't immediately the day after a death say, well, I'm the executor, I'm going to start doing this and this and this. You have to wait on the judge. Correct.
Right.
And but by the same token, let's say, dad passes away and people find out about it, and a week later somebody comes to the house and says, I'll give you $1 million for dad's house today, but you got to sell it to me today. If it's in probate, you can't do that, correct? Unless it's in a trust or something like that.
Yeah. So, like if the will has not yet been probated and that switch hasn't been flipped to give the executor power yet, then nobody can put that house on the market or sell it to anybody else unless it was transferred by some automatic means, like a transfer on death deed or a ladybird deed. If it's part of the estate, then nobody has the authority to sell that house or transfer that house to anyone for any reason, until that switch is flipped on. Then the executor can wheel and deal and sell the house and whatever, and do what's needed to do to go ahead and administer the estate, including selling assets and turning them into cash and then splitting the proceeds among the beneficiaries.
And that's once that switch has been flipped by the judge at the sort of the beginning of probate, right? So that means that they could have authority to act during the actual probate process to be able to make.
The probate process is, you basically file the application to probate, and then there's a 10-day waiting period, that you have to wait for, and then you have to get on the court's docket. And again, that may vary a little bit by county, but then when you're on the court's docket and you go in and you do this quick prove up of the will, then once you have done that prove up, then you will be given by the court letters testamentary or letters of administration, and then you do have the authority. That is the official thing that flips that switch, and it gives you the full authority to act on behalf of the estate.
Got it. Okay.
So even though the will hasn't gone all the way through probate and assets have been given to family members or whatever, that executor can do things, whether it's sell a house or a car or a boat or whatever it may be.
Pay for things.
Pay bills.
They can do it then, yes.
Okay.
I think that's great to know, because I think a lot of people are confused
worried about that process.
Exactly.
Right. That do I not have access to any of those funds to pay for their bills for, 3 months, 6 months, however long it takes.
Yes.
What happens in those cases where potentially the person who passes away with a will has more debts than they actually have assets that are part of the will? Do you still go through a program?
Well, again, it would be a number of factors to determine whether or not it would be beneficial to go through probate or not. But if somebody does go through probate, there's an opportunity for any creditors to file a claim against the estate to see if that they can be reimbursed. But if there's no assets there, then there's no assets there.
Right, and there's usually not an incentive for a family to enter a will into probate if the estate is upside down like that. If the estate owes more than it has, so usually you don't initiate a probate process, but a probate process can be initiated by a creditor. So that's something that that is kind of outside the scope or beyond the scope of this shorter interview, but that's something that can happen as well. So even if you choose as a family, hey, we're gonna this is upside down, we're not going to go to probate, you could suddenly receive a notice from the court saying, oh, this estate is going through probate, and you're going, what?
As the family, though, are you responsible for the debts of the person who passed away?
You are not. It is actually the obligation of the estate, unless you co-signed on something, or there's a lot of possibilities of how you could be, but that question does come up a lot. They say, my loved one passed away, and I don't want to have to go pay all their debts. And it's like, well, they're not your debts, so don't worry about it.
Yeah.
Okay.
The debts die with them to the extent there are not enough probate assets to pay those debts.
Got it. Okay.
Another good thing to know. Y'all given us so much to know. Last thing to ask is, other than getting a trust, is there anything we can do to help the process?
To prevent.
To plan ahead. I know, my mom's not going to last much longer because of Alzheimer's. What do I need to do? Or even for debt, whatever it is, thing that we can work in advance and plan in advance to help this process.
You mean like things like a ladybird deed or transfer on death or beneficiaries or those kinds of things?
Whatever they say.
Yeah.
That's what I was, the things that Kim just said are exactly what I was just going to say, that basically you've, if it's coming, and you want to simplify things, yes, you can go ahead and set up, if the person's competent, you can have them set up beneficiaries on bank accounts. You can do ladybird deeds or transfer on death deeds. You can set up things to to pass separately from probate. And depending upon the situation and what kind of power of attorney you have, an agent under a power of attorney may be able to do some of those things to simplify and potentially prevent having to go to probate.
And be sure and check with your banks and anybody you have money invested with, because just because you've named somebody to be a beneficiary, there could be a little hidden clause or a box checked on their computer that says, we'll release this money after you go through probate. And it's been our experience, if that is kind of hidden in there and to ask that question, you can simply request that they uncheck that box and change it.
Okay.
So.
Okay. And obviously there's a lot more to this, and we could talk probably all afternoon.
And again, things are different in different states. So
Sure.
always check with the attorney in your state.
Right. But hopefully this helps
This answers a
explain
lot
some
of
of
questions.
the terminology and help people have the right questions to
Yeah.
answer.
Yeah.
to
So
ask.
thanks so much for helping clear lots of things up.
Yeah.
Jeff and Keith, we appreciate you both.
Yeah.
You're welcome. Thanks for having us.
Yeah. I think what we always learn, again, is communicate, not only with each other, not only with mom and dad, but talk to an attorney. Talk to mom and dad's attorney. Talk to an attorney that find out what needs to be done to help kind of streamline the process, make it as easy as it can be for you and the family.
The more you have prepared and the more you understand, hopefully the simpler that process will be.
Exactly. Hey, if there's any other topics you'd like us to discuss, please let us know. Parenting aging parents.